Hello everyone, welcome back again to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now, let's start this video. Law enforcement in Indonesia's exclusive economic zone in the framework of Indonesia's national interest in the marine sector. Juridically normative, that is the United Nations Convention on the International Law of the Sea in 1982, which has been ratified by the Law of the Republic of Indonesia number 17 of 1985 concerning ratification of the 1982 United Nations Convention on the Law of the Sea or UN clause, which places Indonesia as having sovereign rights to utilize, conserve, and manage fish resources in the Indonesian exclusive economic zone and the high seas, which is carried out based on applicable international requirements or standards. The exclusive economic zone has a special legal status that is sui generis and sui juris, which means that from the legal points of view, the Indonesian exclusive economic zone area in this case cannot be equated with legal treatment in the territorial area, which is the sovereign territory of a country. If we look further at the legal relevance of the territorial potential of the Indonesian Sea, then of course we will understand the legal theory of sovereignty, which is closely related to the legal understanding of positivism, because it is this positivism legal understanding that discuss this issue a lot. Therefore, it's not surprising that the issue of sovereignty is widely discussed in books written by adherents of legal positivism, such as those by H.L.A. Hart, Hans Kelsen, Friedman, and Longfellow. In addition, at the level of law and international relations related to diplomacy between countries, of course, the state must put forward the theory of state jurisdictions, where every sovereign state must have jurisdictions, therefore jurisdiction will relate to the power of a state. Jurisdiction is the main and central feature of state sovereignty because it is the exercise of authority that can change or create or terminate legal relations and obligations. By looking at the theory of sovereignty and the theory of jurisdiction by Mokhtar 1996, then of course the case level of the exclusive economic zone is a part of marine waters located outside and bordering the territorial sea as wide as 200 sea miles, measured from the baseline from which the width of the territorial sea be measured. The coastal state only have sovereign rights and jurisdiction that are exclusive to its exclusive economic zone. This is a legal problem when there is damage to marine resources, especially in the field of fisheries in the exclusive economic zone, by looking at the potential that exists in Indonesia and the potential for fisheries crime. Fisheries crime is a crime and violation of the provisions and the law governing the management and fish resources in the fisheries management area of the Republic of Indonesia of WPPRA. In terms of fisheries management, there are several international agreements that are oriented toward balanced and sustainable use. The agreements include first, the Code of Conduct for Responsible Fisheries or CCRF, the Committee of the Food and Agriculture Organization or FAO on Fisheries at its 19th session, March 1991, developed a concept that leads to sustainable and responsible fisheries management. FAO recommends the formulation of responsible fisheries management known as CCRF and established in October 1995 to assist fish producing countries, especially developing countries. The CCRF is a guideline for national and international efforts to ensure the sustainable exploitation of aquatic living resources which are in harmony with the environment. Second, the Indian Ocean Tuna Commission or IOTC, an intergovernmental an intergovernmental organization under the auspices of the Food and Agricultural Organization or FAO, which is mandated to regulate various species of tuna in the Indian Ocean and adjacent area. The aim of IOTC is to develop cooperation between members countries through appropriate arrangement so as to encourage the conservation and optimum utilization of tuna stocks and encourage sustainable development in the field of fisheries. Law enforcement at the level of the Law of the Sea Convention that regulates the potential of fishery resources internationally is regulated by UN Clause 1982 in relation to the utilization and management of fish resources. The 1982 Law of the Sea Convention contains provisions relating to fisheries law. The 1982 Law of the Sea Convention contains provisions relating to fisheries law applicable in different types of maritime zones under and outside the boundaries of national jurisdictions. The provisions of Chapter 5 of this convention contain legal arrangement for fisheries under the exclusive economic zone regimes, the exclusive economic zone of two or more coastal countries, and the high seas. Law number 45 of 2009 concerning amendments to Law number 31 of 2004 concerning fisheries. In relation to illegal fishing arrangement carried out by foreign fishing vessels in the Indonesian exclusive economic zone according to the Law of the Republic of Indonesia number 45 of 2009 concerning amendments to the Republic of Indonesia Law number 31 of 2004 concerning fisheries. It states in Article 93, Paragraph 2, namely, everyone who owns and or operates a fishing vessel with a foreign flag is fishing in the Indonesian Exclusive Economic Zone, which doesn't have CP as referred to in Article 27, Paragraph 2, imprisoned with a maximum imprisonment of 6 years and a maximum fine of 20 billion rupees. Imposition of criminal sanction for foreign fishing vessels conducting criminal acts of illegal fishing in the Indonesian Exclusive Economic Zone according to the Law number 45 of 2009 concerning fisheries. With the support of the theory of punishment, law enforcement, and increasing security in Indonesian seas, Indonesian waters, and the Exclusive Economic Zone, which covers an area of 6 million km per second, 3 times the land area, still require great and intensive attention from state security tools. Law enforcement and security schemes in the Indonesian Archipelagic Sea Lands or ALKI need to be improved. The complexity of maritime security issues and problems in Southeast Asia has become the concern of ASEAN countries, which has encouraged the establishment of the Asian Maritime Forum of AMF. Criminal sanction for foreign citizens who commit theft or fish in the Indonesian Exclusive Economic Zone area. Criminal sanction can be included in the stage of applying sanction in criminal law and also providing sanction in criminal law. James Remeling used the term criminal imposition with punishment, namely the conscious and mature imposition by the competent authority on perpetrators who are guilty of violating a rule of law. Complicated problem: if there is a fishing, they can be accused of stealing fish in Indonesian territory, then fleeing to Malaysian territory. On the contrary, stealing fish in Malaysian territory and fishermen fleeing to Indonesian territory, because the narrow strait contains many fish in the Malacca Strait, which are located on 3 national borders, namely Singapore, Malaysia, and Indonesia. Where this strait is an important route in the shipping sector, but often happens problems in the strait have an impact on the surrounding coastal countries. Okay everyone, thank you so much for watching this video. Don't forget to like, comment, and subscribe. See you until the next one. Bye bye.